Hello and welcome to episode 1 of the ABC of Central Ohio Construction Law Series presented by Benesch. My name is Peter Hahn. I'm with my partner Eric Schalander. We are construction lawyers at the law firm of Benesch Friedlander here in Columbus. Today's topic is mechanics liens for private commercial projects. Liens, as you may know, are an interest in land, and they are a very powerful tool for subcontractors to secure payment on construction projects. In fact, there are very few remedies and procedures in place that provide faster and more comprehensive relief for seeking payment on a construction project than mechanics liens do. In a lot of ways, mechanics liens are a lot like mortgages. And in some ways, they're even more powerful than mortgages. And here's why. A mortgage, as you may know, like a mortgage on your house, protects the interests of a lender. But a borrower almost never has to pay more than what the original loan amount was, whatever the amount of the note was. With mechanics liens, however, an owner may be required to pay twice for the same scope of work. For example, if an owner pays a general contractor for an electrical subcontractor scope of work, but the general contractor doesn't pay that sub for that work, it is not a defense for the owner to say to the sub who files a mechanics lien, I'm sorry, I already paid for your scope of work, I'm not going to pay again. Under mechanics lien law, the owner can be required to pay twice. That's a very powerful tool in the hands of a subcontractor when it's used properly. But mechanics liens are also a powerful tool for owners and lenders, not the lien itself so much as the mechanics lien law is. And that's because if a subcontractor or if a contractor fails to follow the requirements of the law, the time provisions in the statute, or the strict requirements that are in the documents, then that subcontractor or the general contractor lose their lien rights, which is obviously very important for an owner. So clearly a powerful tool in the mechanics lien law for both the subcontractors and general contractors and for the owners and lenders. As I mentioned, the law is strictly enforced, the mechanics lien law. The time provisions, the deadlines contained in the statute for filing of documents, recording of documents are strictly enforced. If you're a day late, you're too late. And the information that is required to be contained in the documents is strictly required. And why is that? It's because one of the main purposes of the mechanics lien statute is to make sure that there are no surprises, or at least minimize the surprises that can occur in the payment process. So we don't want an owner to be surprised that somebody suddenly had lien rights the owner wasn't aware of. We don't want a subcontractor to be surprised with not knowing information necessary to secure a lien. One of the goals of the statute is to have all the parties aware of what can happen and what they need to do to protect their own interests. No surprises. One of the biggest reasons why the statute is strictly enforced.
Well, the first step in preserving your mechanics lien rights is a document called a notice of furnishing. And the notice of furnishing is a document that's going to get prepared at the very onset of your construction project. And it's somewhat counterintuitive in that you don't know you need to file a lien until you haven't been paid. And you generally haven't been paid until the end of the job. But if you've waited till that point to start asserting your rights, you're likely too late and you've substantially impaired your ability to lien the project. So the notice of furnishing really provides two purposes. On the one hand, it provides what Pete was just talking about a minute ago, notice to upstream contracting parties that you're going to be on the job and you're going to be doing work. And on the other hand, it preserves your right to file a mechanics lien down the road. So it's very important that this becomes part of your onboarding process at the very beginning of the job, that you prepare and you serve a notice of furnishing on all your projects. Now, the notice of furnishing itself comes from a statute, and the statute tells you the type of information that is required in the notice of furnishing. So what we've done in this slide that you're looking at is taken all the information from the statute and put it into a form document so you can see what it looks like. But it generally includes the information you would think would need to be in here. You know, the owner's address, the name of the owner, the original contractor that the owner contracted with to do the work and their address, who you contracted with, the project name, if there's some sort of common name for the project, and then the address of the project, your first day of work, and then you're going to sign it with your contact information. Now, most of the information you'll be able to get for the notice of furnishing, you'll be able to get from a document called a notice of commencement, which we'll talk about in just a little bit. One last thing in the notice of furnishing, the statute requires a warning to the owner, which is a short paragraph in blue you'll see on this slide. And it essentially just says, owner, I am sending you this document because the statute requires me to do this to really enforce my mechanics lien rights down the road. You'll sign it and with your contact information, and then you're going to go ahead and get that served.
So is there a deadline when that notice of furnishing has to be served? The answer is yes. There's a deadline for almost everything in the mechanics lien statute. And the deadline to serve a notice of furnishing is 21 days after you first begin your work. The particular subcontractor's work, not the work itself. So when you first start your work as a subcontractor on a project, you're required to serve a notice of furnishing within 21 days. If you forget, or you didn't realize it was required, or just slipped your mind or whatever, you can always serve a notice of furnishing later on in the project when you're moving forward. But the protections of that notice of furnishing extend back only 21 days before you serve that notice of furnishing, which means you get lien rights only for the work performed within the 21 days before you served your notice of furnishing. So if you're 100 days in on a project and you forgot to do a notice of furnishing and you serve the notice of furnishing on day 100, you get lien rights only for that 21 previous days. And the first, whatever, 69, 70 days that you performed work, you just have no lien rights for that work. You can still sue for recovery under breach of contract theory, but you have no lien rights. Next question is served on whom? Who does the notice of furnishing have to go to? They always have to be served on the owner. The owner is the most important entity on a construction project when it comes to mechanics liens, because the owner is the one who's the most at risk. As I mentioned earlier, the owner might be in a situation where it has to pay twice for the same scope of work. So the owner needs to know who's on the project, who's doing work, who might have lien rights, who do I need to track down to make sure they've been paid so I don't have to be on the hook again to pay for that same scope of work twice. So an owner will always get this notice of furnishing, and the general contractor needs to receive it as well, because a lien filed on a project could put the general contractor in breach of contract with the owner for allowing a lien to be placed. So the general contractor needs to know who's on the job working under us, so that I can keep track of payments there too. The exception would be first tier subcontractors. They don't need to serve a notice of furnishing on the general contractor because, again, the whole purpose of the notice of furnishing is providing information of who's on the job site. A general contractor already knows which first tier subs are there because they have a contract with each other. So the general contractor is aware. So we're talking about second tier and lower subs would have to serve on the general contractor and on the owner. The next slide says served by whom. I think we sort of just covered this, but just to make it clear, anyone who does not have a direct contract with the owner must serve a notice of furnishing on the owner. So that would obviously excuse the general contractor. General contractor has a direct contract with the owner. Owner is aware that the general contractor is on site. It doesn't need a notice of furnishing from the general contractor. So anyone who does not have a direct contract with the owner must serve the owner with a notice of furnishing. And similarly, anybody who does not have a direct contract with the general contractor must serve a notice of furnishing on the general contractor also. So we keep talking about serving a notice of furnishing. What does that mean? Can you just drop it in the mail, hand it to somebody at the job site? No, the statute has several provisions that provide for proper service of a notice of furnishing and anything else that's required to be served under the mechanics lien statute. And service means hand delivery to somebody who has authority to receive, certified mail, overnight delivery, or any other means that includes written evidence of receipt. The best advice is to use a service that actually provides proof of delivery. Certified mail does that pretty easily. So does FedEx, UPS. You could use a courier service. It will have a sort of chain of custody documentation showing when it was served and who it was served on. But just dropping it off at the job site is not going to. It will not provide you with the evidence that you might need later on if you have to go to court and prove that your lien was properly perfected. All is not lost if you somehow use a different method to serve the notice of furnishing, or if you've lost the written evidence of receipt. The law does have a sort of a safety provision that says if you don't have written evidence and you have to go to court to prove your lien, any kind of preponderance of evidence establishing that you actually served the notice of furnishing on the proper parties will suffice. But that means you're in court. That means you may be hiring lawyers, and that's something you want to avoid. The best thing to do is just either send it by certified mail or by FedEx.
Well, and we've talked about the need for notice of furnishing is to preserve your right to file a lien at a later date. And we've talked about where you get some of that information from, which is going to be this notice of commencement that we've talked about a little bit. But there is a safe harbor in the statute that that provides that if an owner on a private project elects not to file or record a notice of commencement, then the subcontractors would be excused from having to serve the notice of furnishing. Idea being, if again the owner doesn't care enough to get that notice by recording the notice of commencement, then again the subs don't have to do it. So that's again just specific to private projects. You would not have to file or serve, excuse me, a notice of furnishing. So let's talk about the notice of commencement itself. Again, this is just like the notice of furnishing. This is a document that comes from the mechanics lien statutes, and it tells you exactly what it is needs to go in there. It's a document that's generally created by the owner, potentially a lender or the general contractor. And the purpose of the document is to put everyone who's going to work on the project on notice of the information you need, both for the notice of furnishing that needs to be prepared, as well as a lien affidavit that we're going to talk about in a little bit. But this is the one-stop shop to get all the information that you need, and it gets recorded in the Recorder of Deeds office, so everyone has access to it. So we've taken, again, all the language that's required by the statute, and we've put it into a form that you can see on these slides. The general information you need is a description of the property, both the common address that you would use, the mailing address, as well as the more formal legal description that you would find through the recorder's office or the auditor's office that is usually multi-paragraph and explains exactly and can pinpoint exactly where this land is and the parameters of this land, so that you have the right piece of property. You're also going to have a description of the project. So is this a 10-story building? Is this a police station? What is it that we're talking about? It'll have the owner's name and address. There will also be a designee that the owner names or a representative that the owner names that you are supposed to address your notice of furnishing and your lien affidavit to. So you'll have that person's name and their address. It could be, an in-house vice president. It could be an outside lawyer. It could be really anybody. You're also going to have to include who you have a contract with and their address, or excuse me, who the original contractor is and their address. So you'll know who both the owner is, who their designee is, and then who they contracted with to perform the work on this project. It will also identify who the lender is, who's got a construction loan on this, because at some point, if there is ever a foreclosure process, all the parties that have an interest in the property are going to need to be brought in. And if there's a lender that has a mortgage or a loan on this property, that lender would have an interest in the property, and they would be involved in selling the property, whatever would have to happen at the end of the job. You will also need the identity of the surety in here. So if there's a surety bond on this construction project, that person or that company will also be listed here with their address and where you would need to send any claims. Finally, there's a notice in the statute that's required to be included in the notice of commencement, and that's the paragraph you're going to see under number 8 on the PowerPoint slide. And this is statutory language that essentially it's the owner saying to all people on a job, I am recording this notice so that all of you have the information you need to file a notice of furnishing and to prepare a lien affidavit. The second paragraph is also, I've always found kind of entertaining. It says a copy of this notice may be obtained upon making a written request by certified mail to the owner or the general contractor. Never really understood that, because if you're actually looking at the document, you have it. So why you have a notice in there to tell you how to get another copy of it has never really made much sense to me, but that's in there. You'll also then, the owner will then sign it with their contact information. We'll get a notary, you will then notarize it. And at that point, your notice of commencement is complete. And then you will need to go get that notice of commencement recorded.
So as Eric mentioned, the notice of commencement is a document that is prepared ordinarily by the owner. Sometimes the owner is not sophisticated with construction projects. A general contractor will offer to prepare it and record it. Sometimes the lender will do so. This is something that almost never a subcontractor would be responsible for preparing. It'd be very unusual. It's also important to keep in mind that the main function of this notice of commencement is to provide information to everybody on the project, mostly subcontractors and material suppliers, of all the information that they need to be able to perfect a mechanics lien. It gives all information about the land that's being improved, who the owner is, who the general contractor is, everything else. And so the main function of the notice of commencement is to provide information for purposes of preparation of liens. It also, as we mentioned before, triggers the notice of furnishing requirements. So the owner says, there's a construction project that's beginning, here's all the information one would need to secure a lien. Now the responsibility falls on the subcontractors to let the owner know, okay, we are the ones who are performing work under this particular project. And a notice of commencement also establishes priorities, and we'll discuss this in another episode, but it establishes priorities for lien purposes of workers who perform work before the notice of commencement is actually recorded or after, and where the mortgage maybe for a construction lender would fall in priority for lien holders. Where does the notice of commencement go? Ordinarily, an owner would give it to the lender, not required, but the lender might receive it. But it is required for the owner to file the notice of commencement with the recorder's office in the county where the project is located. The owner must also post a copy of the notice of commencement at the job site, serve the original contractor with one of the copies, and then provide a copy of the notice of commencement to anybody else on the project who requests it. So if a subcontractor sends a written request to the owner asking for a copy of the notice of commencement, the owner must provide that subcontractor with the notice of commencement within 10 days of the request. It would not be enough for the owner to say, well, I don't really have any idea what that is. You'll have to ask the general contractor. This is the responsibility of the owner. A sub could also ask the general contractor for a copy, and the general contractor is required within 10 days to provide a copy. So just in summary, if a notice of commencement is not recorded for a project, then there's no notice of furnishing requirement, but that means that potential lien claimants will have to search on their own for the information that they need to be able to perfect a mechanics lien, such as exactly where the work is being done, what the legal description of that work is, and everything else. If the notice is recorded, then potential lien claimants, all that work is done for them. They have all the information that they need to perfect a lien, but they must timely tell the owner and the GC, if they're not in privity of contract with the GC, that they are working on the project, and that 21-day time period applies.
Now, we've gone through the notice of furnishing, which is the document that really preserves your right to have a lien, and it notifies upstream parties of your work on the project. We've talked about the notice of commencement, which is the source of the information that goes in both the notice of furnishing and your lien affidavit. And now we're going to talk about the actual lien affidavit itself. This is your mechanics lien. And this is a document that gets also defined by statute. The statute lays forth all the elements that are necessary to put in your lien affidavit. And we, again, have taken all that information, put it into a form document that you'll see in the PowerPoint. But generally, the information that's required for a private project, this will be filled out by a representative of your company. So the president, the CFO, your project manager, maybe. But you'll put the name of that person, their title, the name of the company, and your address, and that you have furnished certain materials or labor for this particular construction project. You're going to identify who you had a contract with on the job and their address. You're also going to have to include your first and last day of work. You're going to put in that you are owed money from the person that you contracted with. And you're going to have to identify again who that is and their address, how much you're owed, and that you're claiming a lien on this particular piece of real estate. Again, you're going to finally have to put the owner's name in and the legal description of the property. So you can identify it by the address here, but you also need to take the legal description that we talked about from the notice of commencement, that much longer legal description you can get from the recorder's office. It's typically an exhibit to the notice of commencement, and you can make it an exhibit to your lien. You'll need that so that the recorder's office can pair up your lien with the piece of property that we're talking about. You'll sign it and you'll notarize it, and then you'll take that document along with the exhibit that has the legal description, and you'll get it recorded with the county recorder of deeds for the county where the property is located. There are timeframes. There are important timeframes, and these are also determined by statute when you need to get this lien affidavit recorded by. For commercial projects like we're talking about today, it's going to be 75 days from your last day of work. For residential projects, there are some different rules that apply for residential projects, but simply just on a timing perspective for your lien affidavit, it's 60 days from your last day of work. And finally, for oil and gas projects, it's going to be 120 days from your last day of work.
So as Eric mentioned, this process gets kicked off the recording of the lien in the county recorder's office, and that's the easy part. And a lot of lawyers who file liens think that the job is done at that point, because lawyers like to know that you file something in the recorder's office and that's it. Now the whole world is on notice of this lien. That's only half the job, because the statute says that within 30 days after recording the lien, you must serve a copy of that lien on the owner. And when we say serve, we mean the same methods that the mechanics lien law allows for service. We would recommend certified mail or FedEx or UPS or a courier service. If that lien is not served on the owner within 30 days after it's recorded, the lien is not valid, and there's no saving it. So that is a very important step that you cannot forget. So you filed your lien in the recorder's office, you served it on the owner within 30 days. Now what happens? The owner just stroke a check to you and you're all done? That'd be nice. That's not usually the case. That's not usually what happens. There are many opportunities, obviously, for parties to dispute the lien, and many things that can happen after a lien is filed. One is that if the general contractor or if the owner believes that the subcontractor's lien is not valid or overstated, or that the amount is not owed, or for whatever reason, the owner or the general contractor can send a notice to the lien claimant, requiring the lien claimant to commence suit within 60 days. And that's exactly what it means. That means that if the subcontractor who files a lien gets that notice to commence suit, it must file a lawsuit to foreclose on his lien within 60 days after getting that notice. And if they fail to do so, the lien is extinguished. It just goes away. Another option for the owner or the general contractor is to bond off the lien, to essentially purchase a surety bond, so the bond security replaces the security of the lien in real estate. We've heard stories of where an owner or general contractor will try to intimidate a subcontractor to say, get rid of your lien or else I'm just going to bond it off. That's great news to hear for subcontractor, because a lien on land means that you'd have to foreclose and sell real estate and hope that there's equity in that real estate to recover to get paid, whereas an interest in a bond is simply a promise by a surety to pay the money that's subject to that bond. It's a lot easier to collect money off of a bond than it is off of real estate that may or may not have any equity in it. So if a general contractor or an owner bonds off a lien, your security is still solidified. In fact, it's probably better. You need to know that liens expire after 6 years. You file your lien 6 years later, if nothing else is done on it, it will automatically expire and there's nothing you can do to revive it. So within that 6 year period, if nothing else has happened, if you've not been paid, then your only option is to file a foreclosure action to foreclose on that lien and hopefully get paid when the property is sold. And that's a big hope, because the lien is only as valuable as whatever equity is in the property after you take into consideration any liens that have greater priority, such as a mortgage or other liens that have a higher priority for whatever reason, or the property just isn't worth as much. If there's no equity left in the property, the lien will not have any value. We'll speak very briefly about lien waivers. I'm sure many of you have gone through the process of signing lien waivers through the pay application process. There are two different types of lien waivers you might be asked to sign. One is prospective and one is retrospective. A retrospective lien waiver is simply when you're asked to sign a waiver of your lien rights after you've done the work, and either after or at the same time you're being paid for it. That's typical. There's nothing wrong with that. A prospective lien waiver means, however, that when you sign the subcontract, what the general contractor is telling you is you are agreeing to waive any lien rights you will have on the project, regardless of whether you get paid or not. That is such a drastic provision that many states have declared that those provisions are unlawful, unenforceable as a matter of the state's public policy. Ohio is not one of those states. In Ohio, if a general contractor and a subcontractor agree that there'll be no liens on the project and the subcontractor will waive any rights that it has under the mechanics lien statute, that is enforceable, it's valid, it's binding. And so it's also a red flag. If you are asked to sign a subcontract that contains a prospective lien waiver, you should look to see what other provisions in that subcontract will also shift too much of the risk to you, and whether you want to do work with that general contractor or on that project. For the retrospective lien waivers, however, the ones you're probably used to seeing, there are contingent and final lien waivers. A contingent lien waiver is simply one that has a contingency clause in it that says that the waiver of the lien in this document is applicable only upon actual receipt of the payment. So these are the kind of lien waivers you might send along with your pay application. If you send a pay application for $25,000 for work you just performed, you might also submit a lien waiver at the same time saying that you will waive any lien rights you have for that work up to $25,000, contingent upon actually receiving payment of that full $25,000. If you don't receive payment, the lien waiver is not effective. A final lien waiver is just that. It doesn't contain any contingency language. It simply says that you've acknowledged receiving payment for everything on the project, either through a date certain or for the entire project, and you are waiving all lien rights, period. You've been paid in full. So that concludes episode 1 on commercial private mechanics liens. We hope that you enjoyed it. Hope you found it useful. Episode 2 will be on public lien claims. Thank you for listening, and hope to see you again.